Hi class, welcome to my presentation. My presentation is on an offer to compromise. What is an offer to compromise? An offer to compromise is a settlement between parties under the California Code of Civil Procedure. A statutory offer to compromise allows for either the plaintiff or the defendant to propose a reasonable, good faith offer of settlement. Civil Code of Procedure 998 says the following. Not less than 10 days prior to commencement of trial or arbitration of a dispute to be resolved by arbitration, any party may serve an offer in writing upon any other party to the action to allow judgment to be taken or an award to be entered in accordance with the terms and conditions stated in that time. The written offer shall include a statement of the offer containing the terms and conditions of the judgment or award, and a provision that allows the accepting party to indicate acceptance of the offer by signing a statement that the offer is accepted. Any acceptance of the offer, whether made on the document containing the offer or on a separate document of acceptance, shall be in writing and shall be signed by counsel for the accepting party if it's not represented by counsel by the accepting party. 998 goes on to say, if the offer is accepted, the offer with proof of acceptance shall be filed and the clerk or the judge shall enter judgment accordingly. In the case of an arbitration, the offer with proof of acceptance shall be filed with the arbitrator or arbitrators who shall promptly render an award accordingly. If the offer is not accepted prior to trial or arbitration, or within 30 days after it is made, whichever occurs first, it shall be deemed withdrawn and cannot be given in evidence upon the trial or arbitration. For purposes of this subdivision, a trial or arbitration shall be deemed to be actually commenced at the beginning of the opening statement of the plaintiff or counsel, or if there is no opening statement, at the time of the administering of the oath or affirmation to the first witness or the introduction of any evidence. Why would anyone choose an offer to compromise? Well, the law actually prefers settlement and has created several methods to accomplish it. Judges prefer settlement, and the trend has been towards greater judicial involvement. Most clients prefer settlement over the increased expenses and uncertainties of trial. The three basic steps to settle a case are determining the case's settlement value, selling such an assessment to the other side, and getting the client to agree. Since settlements are simply agreements between parties, general contract principles apply. Good practice generally requires that the agreement be in writing and signed by each party, and some local rules require it. The offer must be delivered 10 days before trial begins. Settlements of the case can happen at any time, however. They are usually closer to the pre-trial stage, close to trial. After a settlement is made by using a release, a covenant to not sue, or a loan receipt, the settlement is presented to the court where the case is dismissed with prejudice. A release is a complete discharge or satisfaction of an action, and a covenant not to sue does not discharge parties, but is a contract between two parties in which the plaintiff agrees not to sue or to pursue an existing claim against one or more of the defendants. To draft the settlement, the agreement should clearly state whether it is a release, a covenant not to sue, or a loan receipt, and state what matters it does and does not resolve. The agreement should describe the events involved in this case, since the discharge will only be for those events. The agreement should state the claim of liability and damages and the defendant's denial of them, since it is the compromise of these disputed claims that constitutes the mutual consideration in the agreement. The agreement should state the claims of liability and damages and the defendant's denial of them, since it is the compromise of these disputed claims that constitutes the mutual consideration in the agreement. An effective way of presenting the plaintiff's case is by creating a settlement brochure, which we as paralegals might be tasked with creating. A settlement brochure sets out the background of the plaintiff and, along with the evidence, shows liability and damages. A pretrial conference or case management conference is a meeting between the parties before the court after litigation has begun. This is used to have the parties come together to discuss the settlement possibilities. Consequences of not settling an offer has been made are if an offer is made and not accepted by the other party and a judgment is made that is the same or less favorable to the party that rejected the offer, that party can be held responsible for paying the offering party's costs. This does not mean attorney fees, but rather costs associated with filing with the court. A lawsuit must be terminated after the settlement agreement by filing a motion to dismiss with the clerk. It must be filed with prejudice to prevent the plaintiff from refiling. And here is a sample of an offer to compromise. It's actually form 090, and it's pretty much like filling out all our other forms. You just fill out the information here and check the appropriate box and take it to settlement. Anyway, thank you for coming to my presentation.